Day 2 of jury selection in one of the most high-profile trials in recent memory. Sean Diddy Combs is facing federal charges of racketeering and sex trafficking, and right now, his team and federal prosecutors are trying to figure out which New Yorkers will serve on a jury to determine his guilt or innocence. Who may be ultimately selected to decide one of the most impactful criminal trials in recent years? We're going to break down the big moments that happened today. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Hey everybody, this is another Law&Crime legal alert. So lawsuits allege that antacid use has been linked to increases in stomach cancer and gastric cancer. If you or a loved one were diagnosed with stomach cancer or gastric cancer after using an antacid, you may qualify for compensation. And one of our legal sponsors is partnering with the Driscoll firm, a national firm, helping those injured to ensure their claims are thoroughly presented. Visit antacidclaims.com/sidebar or scan the QR code on screen to answer less than 10 questions and check your eligibility to file a claim. Sean Diddy Combs was back in court today alongside his huge team of high-powered lawyers for day 2 of jury selection. The name of the game is to go through over 100 potential jurors in the next few days, whittle that number down to about 45 or so, and then the defense and prosecution will use strikes and challenges to get that number down to 12 jurors and 6 alternates. And by the way, in case this is a shocker, this is no easy task for these potential jurors, right? Sitting on one of the most impactful, heavily covered criminal trials in years, currently scheduled for 8 weeks. So we're going to cover what has happened today in the process, who may be selected ultimately for this jury. And this comes as not only Combs has just added another lawyer to his team, while the prosecution objected to another one sitting with him. We're going to talk about that. But this also comes as Combs reportedly said yesterday, he's a little nervous, and that's understandable because why? He's facing 5 federal charges. The disgraced music mogul is accused of running a criminal enterprise that was allegedly focused on his sexual needs and desires, hiring sex workers, procuring drugs and baby oil, setting up hotel rooms for elaborate sex parties called freak-offs, and we expect multiple alleged victims, including Combs' ex-girlfriend Cassandra Ventura, to testify that they felt forced or coerced to participate in these sexual episodes. Racketeering conspiracy, sex trafficking, transportation to engage in prostitution. These are the charges. Potentially life in prison if he's convicted. The stakes couldn't be higher. Now, Combs has been behind bars at the MDC, the Metropolitan Detention Center in Brooklyn, since his arrest last fall. He was denied bail multiple times. Sidebar has been closely following this case even before his arrest. Okay, we were covering when he was first hit with the civil lawsuits, but we covered it every step of the way, right? The raids on his properties in Miami and Los Angeles, his arrest, his indictment, the multiple superseding indictments, and all of the pretrial motions along the way. And we will continue to follow this case for you every step of the way, including when opening statements begin, currently scheduled for next week. We're going to cover every second of this. Now, to talk about what happened today, day 2 of jury selection, to talk about today's proceedings, I want to bring in former federal prosecutor Neama Rahmani to talk more about this. Neama, thanks so much for coming on. Really appreciate it. Love having you on to talk about the Sean Combs case. So first of all, the process has been running quite smoothly and efficiently. I mean, do you think they can select a jury this week with opening statements next week? When you told me this, when they told me that jury selection was only going to take a week, I said, no way, it's not going to be able to take a week. But you think it's possible, generally speaking? We'll get into more specifics about what happened today.
Jesse, first of all, love being on, and we're almost there. Next week, I do believe we are going to get a jury selected this week. And I think the reason we are, really there's 2 reasons. One, we're in federal court, and we know these federal judges like to move. They're really limited when it comes to what they perceive as for-cause challenges. If some of these potential jurors say, hey, I can be fair and impartial, that's good enough for most judges. And they'll say, you know what, counsel, you got to use your peremptory on them. The other reason I think we're moving quickly is because we're having judge voir dire as opposed to attorney voir dire. Attorneys can ask all sorts of questions because, look, let's be honest, Jesse, there's only one person in that courtroom that wants a fair and impartial jury, and that's Judge Subramanian. The lawyers, they're going to want jurors who are favorable for their case. I mean, that they're advocates. That's just the reality of it. So lawyers tend to be a little bit more
What did you say? What? They don't want fair and impartial? They want jurors on their side? Neama, what are you talking about?
Believe it or not, Jesse, advocates actually want to win. So,
Yeah.
they'll ask questions, as trying to get into their political beliefs. And really, we want to know, if you're prosecuting or defending a sexual assault case, what are your views on sexual assault? Do you believe it can
Right.
be underreported? Do you believe it can be falsely reported? Is this rape? Is this regret? I mean, we know what the lawyers are getting after. So the judge obviously isn't going to get into all that. Is going to kind of stay within the boundaries of really what should be a for-cause challenge. And that's why I think the process
Yep.
is moving a lot faster than it would otherwise go.
So let's get into a little bit later on about preemptory challenges and how that's going to work. But right now, as these jurors were brought in for initial questionnaires last week where they filled out all the paperwork, answered questions, now there's individual questioning, and they can be stricken for cause. There's a legitimate reason they can't sit on the jury, whether it's a very unique particular hardship or they're showing some sort of bias. And I have to tell you, Neama, there was a little bit of trouble today, right? You had one prospective juror today who talked about hearing about the Combs case on CNN, admitted that they leaned in a negative light towards him having committed some crimes. That juror was excluded. You had another juror who admitted on the questionnaire, again, that all these prospective jurors had to fill out, that she was a victim of an attempted rape. Reportedly said the cops could have done a lot more. But this juror wrote on the questionnaire that P. Diddy has money and he could buy his way out. And when asked by the court, well, what did you mean by that? She apparently doubled down and said, just what I wrote. She was excused for cause. Another juror, who has a son that works in the DA's office of Rockland County, New York, conceded they aren't sure if they could be fair and can't promise they wouldn't be biased. Struck for cause. Another juror who admitted they would be biased for law enforcement, struck from this jury. Neama, I gotta say, this is what I anticipated would happen. Now, first of all, credit to these prospective jurors for being honest, or purportedly being honest, but I expected we would have a lot of people that would show a sense of bias in this case.
I think that's right, Jesse. First of all, in any case, there are a lot of people that just want to get off jury duty, right? They get that summons in the mail and they don't want to be there, especially for a 2-month trial. That's going to get a lot of press and not just attention here, international attention. Now, you have some stealth jurors that maybe want to get on this panel and write a book about it and go on the talk show circuit after this is all said and done. But most Americans aren't really excited to serve as jurors. So you'll get folks that will say anything to get off the panel. Now we're talking about a celebrity, and we're talking about sexual assault, and we know that a lot of people have been victims of sexual assault or sexual abuse. So this may hit close to home, and they might not be good jurors on this type of case. And like you said, they may be honest about their experience, not because they want to get off the panel, but because this may be triggering and they may have to relive through trauma that they themselves have experienced or a loved one has experienced because of sexual assault. So those jurors are also getting off. But like you said, this is the type of case that is going to stir up a lot of emotions from a lot of different folks, whether it's race, whether it's law enforcement, whether it's gender and sexual violence, you name it, this case has it.
And look, these are jurors who have to expect to not only know who Sean Combs is, but they're probably been exposed in the last year and a half to material about him. So whether it's the lawsuits, the CNN video, things like that, they've already formed an opinion about it. So aside from the jurors who, by the way, who mentioned or exhibit signs of bias, you also had other jurors who have conflicts or have medical issues that struck them from the jury too. For example, you had one female juror who expressed she has these stomach issues, needs multiple bathroom breaks, struck from the jury. That's not going to work when you have prolonged testimony and maybe not the ability to have multiple bathroom breaks and is going to be distracted. But we have another issue, another juror, actually, to be more specific, that highlights a key issue in this case. The footage from the LA Intercontinental Hotel of Combs purportedly beating up Cassandra Ventura back in 2016. Key piece of evidence in this case. Combs issued an apology on Instagram when a portion of that video was published by CNN last year. This was before his arrest. And again, we believe this is going to be a key piece of evidence for the prosecution to establish that Ventura, who we believe is victim one in this case, was trying to escape a freak-off, that there was a sex worker in the hotel room, i.e., this is evidence of sex trafficking. At least that's the argument to be put forward by the prosecution. Well, what happened? You got a juror today who reportedly told the court, yeah, they saw the video, and despite this juror saying they could be fair in court, saying that in the court today, on the questionnaire that this juror filled out, apparently the juror wrote they were unsure if they could be fair. But the juror said they would listen to the court's instructions on this. Nonetheless, the juror was excluded. But Neama, this tape, so problematic for jury selection, right?
No question, because like you said, typically when you walk into that courtroom, you haven't seen the evidence in the case, but this is not your ordinary case. Everyone has heard about Sean Combs. Everyone has seen that video. It's disturbing. It is offensive. You know, like you said, I mean, he's holding his towel with one hand. He's beating her as she's trying to leave. How can you not form an opinion? So you have jurors that generally have views on these issues. Then they're bringing their preconceived beliefs about the case because they've all seen the video. And this is one of those unicorn type cases that everyone has already heard about. And there's video evidence. And I expect there to be even more video evidence in the case. So whether it's a case like this or Luigi Mangione, we've all seen the video, Brian Koberger with the bathroom selfie. The jurors that walk into that courtroom, they're going to have prejudged the evidence. So if they say that they can't be fair and impartial either in their questionnaire or an open court, it may be hard for the lawyers to rehabilitate them, right? Because if you're a lawyer in the case and you think it's a bad juror for the other side, you're going to want to try to make them seem fair and impartial to force the other side to use one of their peremptories, not get them excused for cause, because of course, cause challenges are unlimited.
And we're going to talk about peremptory, I promise. Anybody who's interested in it, we're going to get to in a second. But as a former prosecutor, I wonder if the prosecution is not happy about that tape being published by CNN. You know, could you imagine if jurors saw it for the very first time at trial? And by the way, the defense tried in pretrial motions to get that tape or a version of that tape or any footage stricken. They didn't want the jurors to see that footage, but a version is going to be shown to them, or multiple versions in different camera angles is going to be shown. But as a prosecutor, do you think that they are like, oh my gosh, I wish that tape didn't come in, we're having trouble finding a jury? Or because you're so cynical about jury selection, Neama, do you think the prosecution's like, we're happy that tape came out, and I hope we get jurors who have formed an opinion, they're just not admitting it during jury selection?
I think it's the latter. I get it why you want jurors who haven't seen the video, but it's such a disturbing video. And just you and I have talked about it. If you guys are watching, go back and watch Jesse's videos when this came out in May of last year. It's such a powerful video. It was such a powerful video that after denying these allegations for months and months and months, from November 2023 when Cassie filed her lawsuit, Diddy's homes are raided in March. Only in May, when this video comes out, Diddy issues an apology. That's how powerful the video is. So the cynic in me, if I'm the prosecution, I like to overwhelm the defense, and I like the jurors to basically be on my side before the defense even presents their case. I want them to have made up their minds. And when you have a powerful video like this, if I'm the prosecution, I like it out there. I know it can potentially taint the jury pool, and this is me as an advocate, not for someone who's looking for, you know, the fair and just result. The fair and just result is everyone walks in with a blank slate, right? They view only the evidence in the courtroom. But that's just not the reality in a high-profile case like this. That's why, Jesse, there's always the courtroom. But there's the court of public opinion, and the latter does matter.
You know, and you said it very well. We don't know what other videos might be shown. If you take the defense's perspective, I mean, they made an argument in a pretrial motion that the warrants were invalid in this case because they said if the judge who authorized these warrants, if the magistrate court authorized this warrant, saw all the video footage, they would say, wait a minute, I don't see anything illegal here. I think this is all consensual activity, whatever these sex acts that were captured on video. So it'll be interesting to see what is shown and which side it ultimately benefits. But going back to jury selection today, so you had another juror who apparently read an article about the jury selection process going home from the courthouse yesterday. More specifically, who got excluded from jury service. They were looking to see who got excluded from jury service. Now, the judge today admonished this person, saying they weren't supposed to do that. And apparently, the reporting indicates this might have been a lawyer or someone who was trained as a lawyer. If true, you definitely know you shouldn't do this. The court struck this juror, but Neama, it raises a larger question of how tough is it going to be to make sure whoever's impaneled on this jury doesn't talk about the case, doesn't research the case, isn't affected by the media coverage of it, or who's outside the courthouse. That's why I feel like you need so many alternates.
It's really a big problem, Jesse, and technology has just changed the game, right? Back in the day, you weren't getting all your news from your cell phone, right? You have to go home, you got to turn on the TV and watch the news. But we've seen it time and time again, and it's becoming an increasing problem where a juror is Googling about the case, they're on social media, and you're not supposed to bring in those outside facts and evidence into the courtroom. And like you said, a lawyer should absolutely know better. That's not what you're supposed to do. And that's how mistrials happen. So, big issue right now. Now, how do you get around it? You sequester the jury. But again, people already don't want to serve as jurors. Now you got to take their cell phones, confiscate them, separate them from their loved ones for 2 months. It's really a big imposition and a burden. So, if you're the judge, you're hoping the jurors follow your instructions, whether they're on the panel or potential jurors, so you don't have this problem. But it's a continuing problem because, of course, jurors have lives outside of that courtroom.
So, Neama, let's talk a little bit more about who made it through. So it's been reported that 19 prospective jurors made it through day one yesterday. And today you had other jurors who made it through. And by that, what I mean is, and to be clear, these are not necessarily jurors who are going to ultimately sit on the jury. They are making up that panel of 45 or so jurors who then both the prosecution and the defense will strike and get down to the number of 12 jurors and 6 alternates. Again, I'll get to that a little bit more. But who made it through today? So you had one juror who made it through that was a student of psychiatry, is at Mount Sinai in surgical pathology, served as an expert witness in medical malpractice cases, indicated his son was beat up and had his cell phone stolen while in college, and was told that the crime was committed by 3 young black men. Both sides agreed, and so did the court, not to strike this juror. You have another potential juror who made it through, someone who says they may be an elected officer to a union. His wife, according to him, was molested by a family member. And while he said he saw the CNN video, the Cassie video, and claimed that Diddy looked angry and hostile and entitled, he said he could be fair. You had another juror who claimed that he would lose 30% of his income if he had to serve on an 8-week trial, but indicated he could survive it. Also told the court that his wife is suing his landlord for repairs. It's important to know of any legal issues they may have. And also claimed that he has friends who have been assaulted. That person moving forward. Another potential juror is a security guard, has seen the Cassie tape, found it disturbing, but indicated could be fair. She was let in. We have a child neglect social worker coming in too. We have another juror who was let in over the prosecution's objection, by the way, who claimed that he had negative interactions with the police, including over stolen sneakers, claimed the police didn't look enough into it. Also said on another occasion an officer allegedly pushed him during a house party that was being shut down. So, Neama, do you get a sense about what both sides want here in terms of jurors?
I do. Obviously, if you're the defense, you want strong-willed jurors. Ideally, you want someone who's a fan, someone who's skeptical of these types of allegations. This is a gross generalization, but the conventional wisdom in some of these sexual assault cases is you want older, conservative female jurors, people that would not put themselves in that situation. Those are the types of jurors, whether it's a Weinstein or a Cosby type case, might be skeptical of these allegations. I believe the victims, but there are some people when these types of allegations are raised years, sometimes decades later, they don't believe it, or they say, you know what, you decided to voluntarily, associate with a music mogul like Diddy. You were trying to further your career. You were getting paid. This wasn't something that was forced upon you. This wasn't someone that was coerced. This is not sex trafficking. You did the drugs voluntarily. So there's a certain type of profile that the defense lawyers are going to like. And obviously, if you're the prosecution, you don't want those types of jurors. You want people that are going to kind of go along and someone that's going to be more likely to believe the consistent testimony of what you believe. There's multiple victims telling the same story.
And Neama, just because somebody has experience with sexual assault or harassment, or has negative interactions with law enforcement, or has seen a piece of evidence in this case, does it make them automatically disqualified from serving? And that's interesting, right? That might be surprising to people.
Not necessarily. Like you said, if they can convince the court that they can be fair and impartial and compartmentalize and set that episode, set that case apart from this case, and decide the case solely based on the facts and evidence in this case, they're not going to be excused for cause. They're going to be at least on that initial panel.
Now, Neama, to be clear again, this is just the potential jury pool. Everyone I mentioned may not even end up being the actual jurors on this case. What can we expect from preemptory challenges, strikes, and also explain to our viewers what those are exactly?
So we're going through the cause challenge process. Those folks that can't be fair and impartial, or they have a hardship, a financial hardship, or a medical hardship that makes it difficult for them to serve 2 months plus deliberations. Often for these longer trials, you can essentially opt out if you can convince the court that you have some reason. It could be family, it could be professional, that prevents you from serving for so long. Okay, so assuming you're clear that you can be fair and impartial, the parties in any type of civil or criminal case, they get a certain number of peremptories. Those are strikes that they can use for any reason, or really no reason at all, as long as it's not a constitutionally prohibited reason, race, religion, and those sorts of things. So once the cause challenges are done and we have that 45 or so, then the parties start using their peremptories. And each case is different. Typically in a federal case, the defense will get 10, the government usually will get 6, but obviously the judge can modify that as well in each particular case.
Do you think that's going to take a full day? So, for example, let's say they get 45 jurors impaneled by Wednesday. They go to preemptories on Thursday. Should they have a jury selected by Thursday afternoon?
I do. And obviously, the lawyers like to ask all sorts of questions. They'll be going into these jurors' social media, trying to get as much information as they can. The judges asked some of this already. There's a whole industry of jury consultants that do this type of research. They're psychologists. They come, they observe these jurors in the courtroom, how they're dressed, how they're interacting with the court. Are they looking at the defendant? And based on that, they're going to use their strikes on the jurors they think are going to be problematic. And sometimes there's a little bit of gamesmanship. Like maybe you don't like a juror, but you think the prosecution might strike them, or maybe the jurors that are coming up behind them are even worse. So there's a real strategy here when it comes to jury selection as well, especially the use of peremptory.
Now, putting aside the issue of jury selection, before I let you go, there's another issue I want to talk to you about since we last broadcast our previous sidebar. So first, as Law&Crime's Elizabeth Milner reported to us yesterday, famed celebrity criminal defense attorney Mark Geragos was in court yesterday. And what happened today? The prosecution filed a letter with the court today objecting to this, saying that it appeared the defense was consulting with Mr. Geragos and members of his law firm, but they apparently never filed a notice to appear in the case. They also argue that according to the local rules, a lawyer or firm, quote, associated with the defense can't make out-of-court statements that would interfere with the trial. And they cite how Geragos has been talking about the case as recently as a few days ago on his podcast. Let's start there, Neama. Fair argument? Should he be prevented from talking about this? Should he have to notify his appearance in court?
If he's going to do any legal work in the case, you have to file a notice of appearance. If you're not admitted before the court or the state, you have to have someone do your pro hoc vice application. Now, if he's just there as a jury consultant, they don't obviously need to notice onto the case. They don't have to be lawyers. But if you are doing legal work, you do have to be in the case. And we know the Southern District of New York has some pretty strict local rules when it comes to these out-of-court statements. We've talked about it in the Lively Baldoni case, for instance, came up in the Mayor Eric Adams case. You really got to be careful about what you say. Luigi Mangione in the federal case, you really got to be careful about what you say in the Southern District of New York, because again, those local rules there really are limiting in what you can say out of court if it has the potential of tainting that jury pool.
Yeah, and by the way, one more point about lawyers. So Neama, also, as reported by Elizabeth previously, today we got official word that Nicole Westmoreland is now representing Combs at this trial too. So he already had several attorneys, Mark Agnifilo, Tenny Garagos, Brian Steele, expanding the team. What do you make of this?
I think it's important, and we've talked about it time and time again. The person that's going to likely cross-examine these female victims is going to be a female. If you have an overbearing male, it can be problematic. You know, we've seen it with Amber Heard, for instance, right? Camille Vasquez handled that cross-examination. So again, this is conventional wisdom. I'm not saying a man can't cross-examine a woman. I'm just saying what is typically done by the defense bar. So I'm not surprised we're adding some female lawyers. And of course, we know the prosecution team is all female as well.
Well, I'll tell you what, at the time of this recording, they are finishing up day 2 of jury selection. I will be very curious to see what happens on day 3. We plan to cover it more here on Sidebar. Neama Rahmani, thank you so much for taking the time. It was great seeing you.
Great seeing you, Jesse. Excited to be on real soon next week.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.